You are watching Morning Musings with Reinhard von Hennings, chairman and founder of Bridge House Law in Charlotte, North Carolina.
Have you seen the Barbie movie? Hello, this is Reinhard von Hennings. If not, you must have heard about it, or you must have seen something. It's a global hype. Just yesterday, I saw flocks of people, mostly dressed in pink, to go to the movies, and I think I know which movie they wanted to watch. But if you saw it, did you wonder why the Aqua song from the 1990s, Barbie Girl, was only played for seconds and not used as a big theme song? In the grand picture of pop culture, a few songs have managed to capture the imagination quite like Aqua's Barbie Girl. What began as a catchy tune quickly spiraled into a whirlwind of legal battles. Yes, it ended up at the United States Supreme Court. Music in the courtroom. That's nice. This strange and true story not only offers a great glimpse into the complexities of intellectual property, but it also underscores the importance. What can you do? What do you have to do in order to protect your intellectual property, especially in a global arena? What are your global assets? What are your creative assets you need to protect? So let's talk first about the litigation Odyssey. What are the battles? What are the breakthroughs? At the release of Aqua's Barbie Girl in 1997, it propelled the song to instant fame. But it also poked Mattel, the multinational toy company behind the iconic Barbie doll. Claiming trademark infringement, using the word Barbie is trademark protected, and brand dilution, this picture of the Barbie doll is different in the music than it is in the image of the Mattel company. Mattel filed therefore a lawsuit against MCR Records, the Danish-Norwegian band, and this case went on. The case was about the blurred line between parody. Is it really a parody when the song talks about the Barbie girl? Or is it a blatant copyright violation? So, in short, it's good stuff. In 2002, the United States Ninth Circuit Court of Appeals ruled in favor of Aqua. The court stated that the song was a protected form of parody. So, in other words, freedom of speech includes parody, and therefore, because it was a parody, it did not violate Mattel's trademark. The ruling affirmed the importance of artistic expression when it comes to commercial icons. However, the story did not end there. Mattel moved forward and went out to the appellate route. The US Supreme Court, however, declined to hear an appeal from Mattel, effectively solidifying the Ninth Circuit verdict. The outcome highlighted the significance of a very well-established legal argument, legal principle, that protection of intellectual property rights is one part, but fostering creativity and innovation on the other part is important. So it's a balancing game between creativity and copyright. Thus, therefore, there was no need for the United States Supreme Court to hear the arguments again and to rule again because the law is solid. So, now as the case was decided, fast forward to the present times, would Mattel be able to license the song for the movie? Probably, but maybe they did not want to do it. So let's take a look into the current licensing and legal arguments around the Barbie movie. In the present time, the Barbie Girl legacy continues, and it has an ongoing impact in the entertainment industry. With Mattel now producing a live-action Barbie movie on top of the cartoon-type movie they made before, new questions arose about the licensing and legal conflicts. As always, the balance is a challenge. How can we balance the artistic freedom and corporate interests? Filmmakers must navigate the terrain of trademark licensing agreements and intellectual property negotiations. It seems Mattel either did not want to license it as a matter of principle. No, I'm not licensing something from somebody I went in court with. Or the fees Aqua demanded were too high. Or they just felt using the fair use doctrine would be enough to kind of like have a glimpse of the song. So what's that fair use doctrine? Under the United States copyright statute, it's permissible to use limited portions of the work, including quotes, for purposes such as commentary, criticism, news reporting, or scholarly reports. Well, I'm curious how this closing song is now a fair use argument, but a future legal battle may come, and there may be a battle about the closing song as a movie. In the end, Mattel may have just done an economic analysis. Will the movie be successful with a song, or will it be successful without the song? And I think the legal answer was, it doesn't matter whether the song is in. The answer was no, so let's don't license it. So why does this legal odyssey matter to global businesses? It's a great reminder of the implications of intellectual property disputes. It is also a reminder of how in a global connected world, a Danish-Norwegian music had an impact of an American movie maker. Companies, regardless of their size, must prioritize safeguarding in their creative endeavors. In an era where cultural touchstones transcend borders, where music is borderless, where artistic integrity is necessary to be upheld all over the world, it is paramount also to maintain a positive brand image. So, how? Shield your intellectual property, and therefore you need to consider a few strategies. First of all, ensure that you have a comprehensive trademark registration. Secure a trademark protection for your creative assets, and then fight back. Fight hard to deter any potential infringement. And number two, document everything. Maintain a thorough record of your creative process. How did you come up with this idea? Whose idea was it if it was a teamwork? When was it first implemented? How was it changed? This documentation can serve as evidence in later legal disputes along the line, somebody stole it from me. If you can show that it was a parallel invention and 20 folks at your organization worked on it, changed it, mulled over, rephrased it, and so on. And lastly, talk to legal experts. Collaborate with professionals who can help you here. So in the ever-changing landscape of global business, the Aqua Barbie Girl saga reminds me that creativity and commerce can be both allies and adversaries. As a global leader, ponder how this story can be applied to your own ventures. How can you strike the balance, the right balance between innovation and legal compliance? How can you utilize intellectual property to enhance your brand's global presence without infringing on other rights? As you navigate the intricate waters of the business world, how can you harness the power of creativity and intellectual property, not only to drive your company's success, but also to inspire and engage with a worldwide audience? At the end, the saga of Barbie Girl stands again as an enduring testament of the interplay between art and law, a reminder that even the most unexpected legal battles can reshape the course of our cultural history.
Thank you for joining us today. If you would like more information about Bridge House Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. Bridge House Law, business-minded, client-focused.